government contractors. So it's very important. All right. Public sector programs are also important because there's not a broad range of laws that govern business-to-business contracting relationships. So unlike in the consumer industry, right, they're very defined areas. And so that if I wanted to, as a contractor, hire somebody, there's no law, and I'm in the private sector with no government money mixed, there's no law that tells me I can't do that. All right. Minority firms experience disparate treatment in the public sector, but for the existence of public sector programs, the MBE programs, WBE programs, DBE programs, and so on and so forth. And minority firms also have a capacity deficit. That is, there's a deficit. If you look at the relationship for equally situated firms and the capacities of those equally situated firms, there's a deficit, and that deficit is rooted in a number of things. It's rooted in historical circumstances. It's rooted in issues like lack of access to bonding and capital markets and networks and strategic alliances. It's rooted in laws, institutional barriers, and so on and so forth. All right. Let me then, I'm about to bear with me one more minute. I want to emphasize the point. And then I'll move right into what we found for the case of NCDOT. And what I want to do is I want to read from the Georgia legislature, and then I'll read from the North Carolina legislature, an act that was passed in Georgia in 1845. All right, 1845. And here's how it reads, and I'm quoting, Section 1. Be it enacted by the Senate and the House of Representatives of the State of Georgia in General Assembly met, and it hereby enacted by the authority of the same, that from and after the first day of February next, each and every white person who shall hereafter contract or bargain with any slave mechanic or mason or free person of color, being a mechanic or mason, shall be liable to be indicted on a misdemeanor, and on conviction be fined at the discretion of the court, not to exceed $200. All right, end quote. All right, here's a law codified in the state contracting practices that govern contracting practices that in essence makes it illegal for a white person to engage in contracting with a black contractor. Now there's a reason for that. And the reason for that is that if you go back to that period, that in locations like Durham and Raleigh and other major cities throughout the South in particular, the contracting industries, those industries were dominated by black contractors, either as free laborers or as contract slave laborers. And so we see at that time all kinds of acts passed all across the South that were attempting to drive them out of those industries. Right? North Carolina, well, Georgia wasn't alone. Right? North Carolina. To the General Assembly of the State of North, this is 1856, to the General Assembly of the State of North Carolina at the session of 1856, your memorialists, and this is a petition on behalf of some individuals, your memorialists, citizens of Smithfield in the county of Brunswick, some of us mechanics, considering the great injury done us by colored persons in taking contracts at a lower rate than we can afford, thereby depriving us of the means of supporting our families, pray your honorable bodies to pass an act to prevent free colored persons from becoming contractors for any mechanical work such as building houses, vessels, and so forth, and especially to pass more stringent laws against slaves hiring their own kind. The evil has become a serious one, and we most earnestly believe that sound policy, no less than our own interest, requires that white mechanics should be protected against the competition of free colored persons, whether free or slaves. All right, so you had, again, this is a petition, so you had then going all the way back to that era, following up by Plessy versus Ferguson, which codified segregation in practice in law by the Constitution, hundreds of years of a period of time whereby there was inequality in the access to opportunities. And it was not until in the late 70s and early 80s that programs began to emerge, such as minority business programs, the disadvantaged business programs, and others, that allowed the emergence of contractors outside of what we call mom and pop kind of enterprises. But for that, if you are a successful black-owned company, you are successful because you are able to tap into the demand that existed exclusively within the black community. And again, most of those were personal service and retail kinds of establishments. What those contracting programs did was to allow really the first access to the marketplace in those kind of non-traditional areas, so that you got the first large construction contractors. Right? If you were a successful black construction contractor up until then, you were successful. The best thing that you could do was build a black church. Right? There was no involvement in highway construction. There was no involvement in major construction in commercial areas and so on and so forth. So that's the history, and it was but for the existence of those programs, that pattern would still exist today. So when you had contracting opportunities to emerge, you had the emergence not only of construction companies, but architectural and engineering companies, and then all kinds of other professional service companies. You had computer services and sales companies and others. And we see a whole new generation of African American and minority contractors emerging. All right, so now, that's the history. Okay? And I wanted to lay that out so you could understand the history that prompted the emergence of these programs. All right, let's talk specifically about NCDOT. All right, I want to talk about that program. Now, in regards to analyzing the program, there were two things that we had to look at. One, we had to look at the state program, right? And when I talk about the state program, we mean specifically the program that classifies firms as WBEs and MBEs, right? State contracting. And then there's federal contracting, the DBE program. Those guidelines are regulated by Federal Regulation 49 CFR Part 26. In other words, whenever a local agency receives $1 of federal money, it's obligated to put in place federal guidelines. And those guidelines are very specific with respect to things like how do you set a goal for the utilization of various groups. In particular, in the federal program, there's only one goal. Right? The state program, there's more than one goal. So I want to talk about that. But also, in talking about that, it's important to talk about it with respect to case law, because we have to look at how does it comply with the requirements of the case law. There was a Supreme Court decision in the case of Croson v. City of Richmond, that outlined very specific requirements that had to be met in regards to analyzing the effects of, within the context of disparity studies, the effects of minority business programs. All right. One of the most important aspects of that analysis is whether the program passes the test of strict scrutiny. Right? That's the first thing. It sounds like, well, what is all that legal stuff you're talking about? Strict scrutiny simply means that is there documented evidence that can be proven statistically that indicates the organization itself directly or contractors who have engaged in business with the organization have engaged in unfair or discriminatory practices. That's strict scrutiny. The second, what we call prong of that, is whether the program is narrowly tailored, meaning that if you determine that there is a justification for the program and you put in place remedies, are those remedies narrowly tailored? All right. So there are two things. And most recent cases that have come up around the issue of narrowly tailoring. So when we say narrowly tailoring, what does it mean? The most important thing it means is that whether or not there are sufficient race and gender neutral programs that have been put in place prior to or along with, in conjunction with, race conscious goals, race and gender conscious goals, aspirational goals that are set in place on various for various groups. What I found in the case of NCDOT, that they have complied with federal and state requirements in regards to both setting goals as well as narrowly tailoring their program. And one of the most, in my opinion, one of the most impressive aspects about it are the large number of race and gender neutral programs. I mean, we documented that, and you'll see that in the report. They've used some 10 organizations. They have some 13 different programs and outreach. There's a construction management traineeship program, and a number of other programs, all of which have been documented in the study. So that's good. Why is it good? Because if that program is challenged, the first thing that the court is going to ask is it narrowly tailored? And you will recall, if you've read the recent H.B. Rowe decision, that